This morning on the Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you. Good to be with you.
Well, good to be with you as well. Let's get right to it. And one of the big stories last week was the fact that the Federal Trade Commission lobbied an official complaint against John Deere. And we have documented, Roger, many a times in 2024 some of the issues that farmers have with John Deere, some of their policies that they had as well. One of the things you take a look at, and we'll get into the details, but really the claim that the FTC made against John Deere is it going to suffice as to what the FTC wanted to do there against the company?
Well, this is a sticky one, Greg, because the issues are not, they're kind of unique. We've got intellectual property issues that are involved. We have property rights issues that are involved, and they're all kind of tangled together. And we all know that John Deere has faced criticism for restricting repairs of its machinery, and such as tractors and ag equipment. And those typically will include requiring farmers to use John Deere authorized repair services and limiting access to those repair tools and whatever diagnostic software is needed and replacement parts, and then locking software into the machines, which prevents independent independent repair shops or user repairs. So, from John Deere's view, of course, they have poured a tremendous amount into research and development to develop this technology and this intellectual property in the software. And they view when a machine is purchased that, yes, you buy the machine, but they're just merely licensing the use of the technology in the machine to you. So I can understand that from a legal standpoint. Very frustrating, however, from a farmer standpoint, who needs to be able to make repairs quickly, particularly during harvest time, and the remote locations might mean that a dealer can't get to you in a timely fashion. And of course, farmers are up against the clock, not just the clock, but the weather also. And you got to hit certain windows to maintain peak productivity and economic efficiency. And so this makes it difficult for those farmers. Now, when you overlay that with antitrust law, which is where this gets really deep into the weeds, there's potential, and I'll just say potential antitrust issues with John Deere's policies. And I think you can put them basically in four boxes, so to speak. One would be monopolization by limiting who can repair its machinery, and John Deere has the corner on the ag machinery market. They are a major market player. That would be one. Tying arrangements would be another one. So if John Deere ties the purchase of its equipment to mandatory repair services or their proprietary tools, that could be a violation under antitrust law. But you have to have two products. You have to be able to tie one to the other. So the question here is the technology in the machine a separate product from the machine that was purchased? And I'll tell you, Greg, from a tax standpoint, if we're determining whether to currently deduct a repair to an engine or an overhaul of an engine in a tractor, or whether I have to capitalize that, what we worry about there is whether we have a single unit of property or whether we have two. Well, a tractor doesn't function very well if it doesn't have an engine in it. So that is what we would call one unit of property, or a UOP. I don't know if the tax analogy is solid enough to apply in the antitrust context, but that's one way to think about it. Do I have one unit, or do I have two that are tied together? Because you have to have two to have an antitrust violation. Then I think a third box would be exclusive dealing. If there's restriction of access to essential repair parts and software for independent repair shops or customers, that could be seen as exclusive dealing, and that's a violation of antitrust law. And then, of course, consumer harm. That's the fourth box as I see it. Antitrust law prioritizes consumer welfare. Well, the farmer here is the direct consumer. So Deere's policies could increase repair costs, reduce repair options, cause delays, and that's what gives FTC concern. So Where this goes, not sure. Now, this was a 3-2 vote by FTC and their commissioners to go ahead with this complaint in light of efforts by John Deere and major farm organizations in certain states to work on memorandums of agreement, memorandums of understanding to work this out. And they were in the process of that. So I kind of, I guess from a cynical standpoint, I view this as last minute by these 3 outgoing commissioners that are no longer there after today. They will be replaced. And 2 that dissented on this and said, look, we need to keep working on these agreements that we have. And I think, Greg, it's entirely possible after today and the remake of the FTC commission that they drop this, or this will end up in some sort of settlement. I can't see it going to court.
Yeah, and that's the biggest thing. John Deere in their statement earlier or last week basically, pretty much countered everything that was said. But yet I seem to remember seeing an article saying, yeah, we're working on some of the instructions, some of the things that can help the individuals who bought our product being able to do that. And obviously, as you mentioned, those memorandums of understanding that they were working on as well. I mean, not a big surprise as to what John Deere said last week either.
No, not at all. And if there's one analogy here, I'd go back 35 years. And I've got some personal experience with this one because I had a brother that was involved in the litigation. But in 1996, Kodak settled a case with the Department of Justice without admitting wrongdoing. And what that was an allegation by the Department of Justice that accused Kodak of engaging in anti-competitive behavior through what they called their Color Watch program. This has to do, and some people might remember this when we actually dealt with film, and you had to have that film printed on paper. Well, Kodak developed what was called Color Watch, and they required participating photo finishing labs to buy a substantial portion or even all of their photo processing supplies exclusively from Kodak, which that was a tie-in. That by tying participation in that Color Watch program to the purchase of Kodak products, then Kodak was effectively excluding rival suppliers from competing for business with those labs, and that strengthened Kodak's dominance in the marketplace. Well, as we all know, you fast forward 35 years and change of technology, and the big yellow dog is no more. But that has some similarities to what's going on with this. That involved technology 35 years ago when that started in 1990, and then it took 6 years to settle that litigation. I kind of see the same thing here. I think they'll work to some sort of settlement on this. There'll be some type of agreements that come out of this. But this is a very important issue for farmers, and I think this could help fashion what the future is with respect to repair rights for farmers.
Another big decision that was made last week by the Treasury Department concerning the impacting of the biofuel tax credit, or in this case, looking at the interim guidance for biofuel feedstocks. This is all tied in with what has been long waited for, the 45Z tax credit.
Well, it's kind of tied in, I would say that. And this kind of broke at the same time the John Deere FTC complaint broke too last week. So last week was kind of a big week. And this is technical guidance that USDA is putting out to allow farmers to quantify greenhouse gas emissions associated with corn, soybean, and sorghum grown using what USDA has come up with by defining climate-smart agricultural practices. And so what this does is it provides a framework for reporting and tracking the information through the supply chain. Now, the USDA said the rule was provided to quantify, verify, and report greenhouse gas reduction benefits that resulted from farmers implementing these acceptable government-approved farming practices in the production of commodities that are used in biofuel feedstock. It's not, however, it's not the final word for the clean fuel production credit under Section 45Z, which is the new one this year. We went from 40B last year to 45Z now, which is good for 25, 26, and 27. Then it expires. The Treasury has to issue more guidance that integrates those climate smart ag practices into the calculation of the credit. So the credit's not operable. It's still not operable until the Treasury tells us how we're supposed to do this. So we can't use 45Z. It's going to be interesting. What's going to happen here? We're going to get a new Treasury Secretary. We're going to get new guidance for that administrative agency, and they may say, "Forget it. We're not going to do this," or they'll go ahead and do it. So this is still unknown as to what the future of this fuel production credit under 45Z is.
Yeah, and that's one thing that this late, well, obviously this late as far as the soon-to-be previous administration being able to do that and then transferring over to the new
Right.
administration, where this goes is still anybody's guess.
It is, and at my tax seminars over the past year, I would go through the details of what 45Z meant, and you could hear the chuckles amongst the practitioners in the audience, realizing this is not workable at all, and their GREET model doesn't work. So it'll be interesting to see what the Treasury comes up with on this. But I would add that this interim rule that USDA just put out is open for comments until March 18. Now they said it's effective January 17th, but it's just an interim rule, and so they've got to open it up for comments. And in conjunction with that, USDA did put out a feedstock carbon intensity calculator for peer review and lab testing and public feedback.
It is our biweekly visit with Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, on this edition of the Ag Issues program here on 580 WIBW. You know, Roger, estate planning has always been very important, and now you kind of add into the fact that with the fall election and everything else that has, could be changing, will be changing, depending on your point of view on this as well. But with the election and everything else, what are some of the general implications on what we could see coming up with the new administration as far as estate planning is concerned?
Well, that's a good question. That's, I think, the $60,000 question that all of us are trying to answer on behalf of clients in terms of figuring out where we go with this. In the fall election, of course, the Republicans swept, maintained the House slightly. It's 220-215 there, so you only have a couple of votes to lose there. Regained the Senate with a little bit more and have a little bit more margin than they had previously. That's 53-47. Now, had the Democrats swept, everyone was anticipating substantial tax increases along the lines of the Senator Warren tax proposal, and I think that seems assured not to occur now for the next 4 years. So at least we have that certainty. And the Trump victory suggests that it's unlikely that significant new taxes will be imposed on the wealthy and others. And since the Republicans won the House, more tax cuts might be possible. So what does that mean for estate planning and the political trade-offs that are in there? Well, there is a political trade-off for the promise of the current favorable income tax environment versus estate tax reductions. So that means that it's possible that the Republicans could determine that it's not worthwhile putting the political capital towards maintaining that basic exclusion amount at the current level, which is $13.99 million per individual, or almost $28 million for a married couple. So the reduction in the applicable exclusion amount is already baked in the equation. That basic exclusion amount will get cut to about $7 million if Congress does nothing, and so that's where all the concern is. And of course, we've got rules in the Senate under the current Senate rules that you can stop a bill in the Senate if there aren't 60 votes in support. Now, it can be filibustered, but a filibuster can be broken, which would then require 60 votes to pass. Now, you can get through the House on a simple majority, and so that it's more difficult in the Senate to get tax-related legislation through. But there's two exceptions to that 60-vote rule in the Senate. One is for judicial appointments, and of course we don't care about that in this context of estate planning. The other one we do, and that's budget reconciliation. And so you hear a lot of discussion now. We're going to do one big bill, or we're going to try to do two of these budget reconciliation bills. That's where you have to watch in terms of what the rules are going to be with respect to estate planning. And then they run up into what's known as the Byrd Rule, which is a Senate procedural rule that requires any bill that reduces taxes to be eliminated within 10 years unless at least 60 senators vote otherwise. I don't think they're going to get that. So what we would still have is not permanency. We could get a 10-year extension of additional of a current law to keep that exemption up and keep it inflation adjusted. I can't see it falling at this point in time. But again, I go back to that trade-off. There are a lot of income tax proposals that President Trump has thrown out there. And you could make an argument that the basic exclusion amount could come down a bit, say to 10 million. Maybe that's a trade-off they do. Well, in any event, this really raises the issue of what are we supposed to be doing for clients? What's the best position that I could possibly be in with my estate plan for my farm and ranch right now, given this level of uncertainty? And that is the real big issue. But that's kind of the politics behind it all.
Yeah, and so in one aspect, that it would seem that a flexible plan would be the way to go. But the question is, what are some of the ways, and I think you mentioned some of those, that you can maintain the flexibility?
Well, one is you're right. You have to maintain flexibility. You don't want to get locked into a plan and then Congress go the opposite way than what your plan was structured for. So we want to be flexible, be able to go either direction once we see what the rules are going to be. And one of the ways we do that, we can do that with a standby trust, which is basically a trust that is sitting there and it's ready to be funded at the last minute if we need to. That's some type of revocable living trust, and that gives us a lot of flexibility there. I also talk about on this issue what I call a Q-tippable trust, which involves transfers to the trust that will qualify for the marital deduction if you make an election on a gift tax return. So this is how I can benefit my spouse with basically a life estate with a remainder to specific individuals, perhaps the on-farm heir, and then come in and make an election after the fact on a gift tax return by the 2026 extended filing deadline. So that allows me to get past the end of this year where we'll know what the rules are going to be. Other things to do, we can use disclaimer language, powers of appointments, we can use rescission techniques, and of course, we always have to keep in mind access. Clients are going to want to have access to those assets while we're in this interim period here, and that might actually be more important than the incremental estate tax inclusion risk that access providing might occur. There are various types of trusts we can use on that, and we got some weird acronyms for those. We have DAPs and hybrid DAPs and CRATs and SLATs and IDGITs and all types of things with particular language that we can use in those to provide flexibility to give us access to those assets. And of course, for farmers and ranchers, asset protection is very, very important, as well as income tax considerations and maintaining that basis step up at death, because there's a lot of low basis farm assets and land that we want to preserve the ability to step up that basis at the time of death when those assets transfer to the next generation. So we always have to keep that in mind too. And then always review existing plans. So this may be a good time when you're thinking about what to do in this time of uncertainty. If you've got an existing plan, go in and review it, talk to your practitioners on this, and try and get the best flexible plan that meets your goals and objectives until we know what the rules are going to be.
Yeah, and the point being, if something is done in the budget reconciliation, that we could have this same conversation 4 to 6 months from now, and it could be a completely different ballgame too.
That's true, and we all hope that they let us know what the rules are sooner than later. We'd like to have at least a half a year before we move into 2026 to be able to adjust and counsel clients and get things aligned properly. Last thing we want is something at the end of the year or even beginning of next year made retroactive. That is just terrible. So let's hope they get things done sooner rather than later.
Because, and correct me if I'm wrong, the budget reconciliation, I think they've got that scheduled to be in the first quarter of this year.
Yes, they do. They're shooting for signature by President Trump by Independence Day, which would mean to me we're going to have about 2 to 3 months of President Trump going across the country and getting public support for it. And then the legislation being voted on April and May to the president's desk by Memorial Day, signed by July 4th. That's the timeline that I'm seeing. That's workable. and hopefully they can get that done.
All right, sounds good. Roger, we're out of time, but as always, appreciate it. And usually this time of year, we look at some of the top 10 things as well. So, as always, definitely looking forward to that, too.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest on the Ag Issues program here on 580 WIBW.